Welcome to California Bar Prep, your study companion for the California Bar Exam. In this lesson, Criminal Law and Procedure Advanced, Search, Miranda, and Counsel. Let's begin. Criminal procedure questions are constitutional timing questions. Ask who acted, what right was implicated, when the right attached, whether it was invoked or waived, and what remedy follows. Most wrong answers confuse Fourth Amendment search rules, Fifth Amendment Miranda rules, and Sixth Amendment right to counsel rules. Keep the amendments separate. The Fourth Amendment regulates searches and seizures. The Fifth Amendment regulates compelled testimonial self-incrimination and Miranda custodial interrogation. The Sixth Amendment protects counsel after formal charges and confrontation at trial. Government action. The Fourth Amendment applies only to government conduct. Private searches are not covered unless the private person acts as a government agent. Search. A search occurs when government intrudes on a reasonable expectation of privacy or physically trespasses on a constitutionally protected area to obtain information. Homes receive the highest protection. Open fields receive no Fourth Amendment protection. Curtilage may be protected depending on proximity to home, enclosure, use, and steps taken to shield from observation. Standing. Fourth Amendment rights are personal. A defendant may challenge only a search or seizure that violated the defendant's own reasonable expectation of privacy or property interests. Overnight guests often have standing. Casual visitors for commercial transactions usually do not. Seizure of persons. A person is seized when a reasonable person would not feel free to leave or terminate the encounter. Arrests require probable cause. Brief investigatory stops require reasonable suspicion supported by articulable facts. Seizure of property. Property is seized when the government meaningfully interferes with possessory interests. Probable cause is generally required for significant seizures. Warrant requirements. A valid warrant must be issued by a neutral and detached magistrate based on probable cause and describe with particularity the place to be searched and items to be seized. Probable cause. Probable cause is a fair probability that evidence or contraband will be found in the place searched or that the person committed a crime. Informant tips are evaluated under totality of circumstances, including reliability, basis of knowledge, and corroboration. Search incident to arrest. After a lawful arrest, police may search the arrestee and areas within immediate control for weapons or evidence. For vehicles, police may search incident to arrest only if the arrestee is unsecured and within reaching distance of the passenger compartment, or it is reasonable to believe the vehicle contains evidence of the offense of arrest.
Automobile exception.
If police have probable cause to believe a vehicle contains contraband or evidence, they may search the vehicle and containers that could hold the item. The justification is mobility and reduced expectation of privacy. Plain view. Police may seize evidence in plain view if they are lawfully present, have lawful access, and the incriminating character is immediately apparent. Consent. Consent must be voluntary. A person with actual or apparent authority may consent. If two present co-occupants disagree, one consents and the other objects, police generally cannot rely on consent as to the objector unless the objector is lawfully removed for reasons unrelated to avoiding objection. Exigent circumstances. Exigency may justify warrantless entry or search when there is hot pursuit, imminent destruction of evidence, emergency aid, or risk of danger. Police-created exigency is problematic if police violate or threaten to violate the Fourth Amendment. Stop and frisk. A Terry stop requires reasonable suspicion of criminal activity. A frisk requires reasonable suspicion that the person is armed and dangerous. The frisk is limited to a pat-down for weapons, though contraband may be seized under plain feel if immediately apparent. Special needs. Some searches outside ordinary law enforcement, such as certain school searches, border searches, probation searches, and inventory searches, are judged by reasonableness rather than ordinary warrant requirements. Rule. Evidence obtained in violation of the Fourth Amendment may be excluded from the prosecution's case in chief. Derivative evidence may be excluded as fruit of the poisonous tree. Exceptions. Independent source. Evidence later obtained from a lawful independent source is admissible. Inevitable discovery. Evidence that would inevitably have been discovered lawfully is admissible. Attenuation. Connection between illegality and evidence may become sufficiently remote. Good faith. Officers reasonably relying on a defective warrant or statute may avoid exclusion unless reliance was unreasonable. Limits. Exclusion generally does not apply to grand jury proceedings, civil proceedings, parole revocation, or impeachment of the defendant's trial testimony. Knock and announce violations do not usually require suppression. Miranda trigger. Miranda warnings are required before custodial interrogation. Custody means a reasonable person would feel not free to terminate the interrogation and leave, approximating formal arrest. Interrogation includes express questioning and its functional equivalent, words or actions police should know are reasonably likely to elicit an incriminating response. Warnings and waiver. Police must warn the suspect of the right to remain silent, that statements can be used in court, the right to an attorney, and appointed counsel if indigent. Waiver must be knowing, voluntary, and intelligent. Invocation of silence. A suspect must unambiguously invoke the right to remain silent. Police must scrupulously honor invocation, but may later resume questioning in some circumstances after time passes and fresh warnings are given. Invocation of counsel. A suspect who unambiguously requests counsel may not be interrogated further unless counsel is present or the suspect initiates further communication. This protection is not offense-specific for custodial interrogation. Voluntariness. Even if Miranda is satisfied, a confession must be voluntary under due process. Coercive police conduct is required. Involuntary confessions are inadmissible for substantive use and impeachment. Attachment. The Sixth Amendment right to counsel attaches when formal judicial proceedings begin, such as indictment, information, arraignment, or formal charge. It is offense-specific. Deliberate elicitation. After attachment, government may not deliberately elicit incriminating statements about the charged offense without counsel or valid waiver. This includes using informants to deliberately obtain statements. Lineups and identification. Post-charge lineups and show-ups are critical stages requiring counsel. Photo arrays generally do not require counsel under the Sixth Amendment. Due process separately bars identification procedures that are unnecessarily suggestive and create a substantial likelihood of misidentification. Confrontation. The Confrontation Clause bars testimonial hearsay against a criminal defendant unless the declarant is unavailable and the defendant had a prior opportunity to cross-examine. Statements to police during an ongoing emergency are usually non-testimonial. Statements aimed at proving past facts for prosecution are testimonial. California criminal procedure may provide additional statutory protections and has its own exclusionary and state constitutional doctrines. California essays may ask for both federal and state analysis. MBE questions test federal constitutional minimums. Miranda is custody plus interrogation. A traffic stop alone is usually not custody for Miranda. Sixth Amendment counsel is offense-specific and attaches only after formal charges. Fifth Amendment counsel under Miranda is not offense-specific during custodial interrogation. A Fourth Amendment violation does not automatically suppress if good faith, inevitable discovery, independent source, or attenuation applies. Consent searches require voluntary consent and authority, not probable cause. Procedure questions often involve a timeline: stop, frisk, arrest, station questioning, lineup, informant, trial testimony. Mark the moment each right attaches. Fourth Amendment starts with search or seizure. Miranda starts with custodial interrogation. Sixth Amendment starts with formal charge. The correct answer usually follows from timing. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.